Good afternoon, ladies and gentlemen. Ethan Fogg, Canandaigua Chamber of Commerce. I'm here with Serena. Serena is from Underberg Kessler.
Yes.
Fantastic. Good friends of ours. They've been doing several Tuesdays at 2 with us. Serena Compitello is an attorney on their team, and we're here today to talk about contract law within the context of COVID-19, because in the work that we do every day with our clients, our vendors, our business partners, many of those relationships are really defined by the law. They may not feel that way when we walk down the street and shake hands or bump elbows, I suppose, right now. But there's a legal underpinning to really all of our business relationships. And I'm hoping that Serena, as our thought leader in the room today, can share some best practices, things to consider, and there will be an opportunity for questions. So, Serena, the floor is yours.
Thanks, Ethan. Hi, everyone. As Ethan mentioned, I'm Serena Compitello. I'm an attorney at Underberg Kessler, and I practice in our corporate practice group. And kind of the purpose of today's conversation is to really talk about, contracts during COVID-19, the enforceability of those contracts, regardless of what end of the contract that you're on, and different defenses that might be available to you, or someone else may claim that they want to have their performance excused under a contract, and if someone's coming to you as the other party, how you might think about that. I think a lot of us have seen different things floating around since the onset of COVID-19, probably beginning in February. Do I have to follow my lease? Do I have to do X, Y, Z? And maybe different legal terms that are popping up. One thing we've been seeing a lot of people talking about force majeure. So I think it's important as business owners and people who are parties to contract to know what these terms are and to know what defenses to contract, might be available to you. Or again, if someone else is claiming, defense to their performance, how we might be thinking about it, from either end. So the first thing that we're going to talk about today is force majeure. It's a term that's been floating around there a lot. It's not exactly intuitive, but it's French for superior force. And so this is a clause in a contract that relieves a party of obligations based on unforeseeable circumstances, things that we kind of think of like acts of God. So these are things that really are not anticipated or controllable. We don't expect them to happen on a day-to-day basis. But what we do in our contracts is we often include a clause called a force majeure clause that says, in the event of X, Y, Z, a party's performance is excused or suspended for a certain amount of time, depending on what the language of the clause says and what those circumstances are. So I've included in the materials today, and we may be distributing those later. I'm not sure, Ethan, you can let us know, but what a sample force majeure clause looks like. Typically in a contract, there's no label that says, this is your force majeure clause. So if you are a party to a contract and you're going through, you kind of know what you're looking for and what that language is. So a typical force majeure clause might say something like, the party's performance under the contract is excused because of events such as fire, telecommunications failure, labor shortages, riots, acts of war. Some older contracts may or may not include things like pandemic, epidemics, plagues, flus. They're all very different. And I'll tell you, to be honest, I think now that with COVID-19 going on, folks are paying a lot more attention to what exactly is included in their force majeure clauses. Obviously prior to the last couple of months, none of these contracts are going to say COVID-19. So if you're looking at your force majeure clause and you want to have your performance excused under the contract or other parties coming to you, we have to look at, well, what other categories might your circumstances fit into? Did we say epidemic? Did we say pandemic? Did we say acts of government, right? We've had a lot of executive orders that have come down, limiting what people can and can't do. So it's kind of, really thinking about how our specific circumstances fit within the language of the contract as drafted. So that's kind of the first thing that we look at is, what does your contract say? It's important to note that force majeure clauses are very narrowly construed. If a court or anyone is looking at this, they're going to say, well, what did you agree to, right? If you wanted to include riots, but you didn't include riots in your contract, we're not going to write that in for you just because it happens to be an issue now. So I think on a going forward basis, again, you know, we're all thinking a lot more about types of risks that we want to guard against. And really, you know, that's one of the big things that we do in contract law is we allocate risk. You know, in the event of XYZ, what's going to happen? How are we going to deal with it? You know, who bears the burden? So that's, you know, really in large part, you know, a function of our contracts. So again, you know, these are narrowly construed. If someone wants to, you know, invoke a claim of inability to perform because of a force majeure event, there's two things that have to happen. You know, as I just mentioned, the event complained of must be specifically provided for in the contract. And then following that, that condition must have actually prevented performance. So think about a situation where you have someone who's, you know, required to ship goods, you know, to a manufacturer that are going to be incorporated into something. And they're failing to make shipments timely, you know, in a complete manner starting in December. You know, COVID-19 happens, we're in February, March, April, and that party wants to say, well, due to COVID-19, you know, I just, you know, for XYZ reasons, I can't meet my obligations under the contract. Well, you know, any savvy attorney or business person or court is going to say, well, hey, you know, you stopped performing prior to the onset of this event. This really is not what prevented your performance. So it's really those two things. Is the event complainant specified in the contract, and did it in fact prohibit your ability to perform? There's things that a force majeure clause will not cover, things that are just annoyances, things that are frustrating, things that are difficult, adverse economic conditions. Aren't going to pass muster for this particular invocation of an argument that you should not be held to your performance obligations under the contract. One thing to look at in a force majeure clause is what we call kind of like a catch-all provision. So a lot of force majeure clauses, and if you look at the example on the one in the materials provided, will say, you know, or any other circumstances, you know, reasonably related to the ones listed herein. Again, in New York, it's construed very narrowly. So if you want to invoke kind of this catch-all clause, we're really talking about events that you could say still fall within one of these categories that have already been addressed. It can't be so far out of the realm of what we've already specified in the contract, because what courts, you know, throughout the country, and especially New York, will say is, well, you know, if you wanted to agree to something in your contract, agree to it, you know, put it in there. And we're happy to help enforce that, but we're not going to bring things into the contract that you yourself did not agree to with another party or negotiate with another party at the outset. And, you know, kind of the importance of that is, you know, both abilities having expectations. I mean, they can look at a contract and know what their obligations are, they know what they're subject to, and we want to provide parties with certainty. And so again, you know, in addition to allocating risk, right, contracts provide certainty about what your obligations are, when performance would be excused. And, you know, that's another underlying reason that courts, again, are unwilling to kind of bring terms that were not already included in a contract in, because it disrupts the parties' expectations. You know, again, if you're in a situation where you're thinking about whether this might apply to you, you know, whether you want your performance excused or another party is coming to you and saying, hey, I want my performance excused by invoking a force majeure clause, it's very important to look at the particular language of your contract. You know, firms and specific attorneys, I mean, it can vary from attorney to attorney within a firm about the exact language that they use. You know, I don't know that I've ever really seen two force majeure clauses the different attorneys use that are exactly the same. You know, these are not really cookie cutter things. They're crafted, they're negotiated, they're drafted. So you've got to look at the specific language in your contract, you know, and kind of talk with your attorney about whether the circumstances you're complaining of really fit within that, or on the other side, if the circumstances another party is complaining of really fit within that, and whether it's a proper invocation. So force majeure is kind of the first thing that we look at if a party is looking to have performance excused. We look first to the four corners of the document. You know, there is a tradition in contract law that parties have freedom to contract, right? You know, you have the ability to enter into an agreement, you know, with Bob and say, you know, Bob and I want to agree to X, Y, Z, and we're going to put that down in writing. So, and to back up a little bit, one of the things that's important to think about too is, and we'll get to this a little bit later, is just because you've entered into an agreement doesn't mean you can't later then enter into a different agreement to agree differently. You know, so that's something we'll get to later when we talk about kind of practical considerations and thinking about, you know, these different doctrines. So first what we do is, you know, we look at force majeure and we look at the four corners of the document and say, okay, does my contract cover the circumstances at issue? You know, the challenge is again that this is very narrowly construed. So if force majeure doesn't apply to you, another thing that you might want to think about are what we call defenses to contract. These are kind of case law creatures that have developed over time, and courts have acknowledged these doctrines. We call them equitable defenses. Equitable just meaning, you know, fair, because it would be unfair, right, to expect performance given certain conditions. Again, these are very, very limited. Courts are very reluctant to disrupt the agreement of the parties, particularly when you have, you know, a solid agreement in writing. But the first thing that we'll talk about is frustration of purpose, which, you know, may or may not apply given the circumstances at hand. And this is a doctrine that allows termination of a contract when unforeseen events, the principal purpose of which is the contract, happen and completely disrupt the whole purpose of the contract. It's got to be a total and complete frustration. And so kind of, you know, for me, thinking back to, you know, law school, contract law 101, they give you this classic example of a hotel is renting out viewing rooms for a coronation, you know, that's going to take place. And so people enter these contracts to get these viewing rooms to go watch the coronation. Well, the coronation never happens, right? So now you're in a situation where the whole purpose of the contract was frustrated. The hotel specifically marketed, you know, these viewing rooms for the purpose of viewing the coronation. And but for the coronation, no one would have rented the rooms to go view anything. There would have been no purpose in doing so. So the idea is that, you know, we're assuming that something isn't going to happen that completely undermines our wanting to enter into this agreement. Now you're in a position where it makes no sense, right? You don't need the agreement anymore. It does nothing for you. So there's limited circumstances in which this applies, but one area that we can talk a little bit about and we'll get to is specific events. For example, if you have an artist, you know, you entered into a contract for a venue because a specific artist was going to perform, that artist can no longer be there. You know, the purpose of the contract is frustrated. So that could be a situation when we're looking at specific events where the event is no longer possible. And so what are we going to do now, right? Like there's no purpose to doing this. You know, there's other examples. One of the materials is company A leases commercial space for the purpose of displaying art and for the retail sale of art, and they have an ancillary use where they're going to use some of the space for office space. So the company claims that executive order requiring all non-essential employees to stay home kind of frustrates the purpose of their contract because no one can go to work anymore and therefore they don't need the office space. So again, this is a very facts and circumstances situation where, you know, a court is likely to say, well, maybe you can't take full advantage of the contract, right? But we, you know, the stay-at-home order is, you know, short in duration and compared to the length of the contract, right? You've got a 2-year lease. So people are home for a little while, but you're still going to get the benefit of your bargain, you know, to a large degree. So in that case, you know, you're probably not going to be able to invoke this frustration of purpose argument because your purpose isn't completely frustrated. It has to be complete and total frustration.
Serena, if I may, a couple of things that have come up a couple of times that I think may help create some nice bedrock to stand on moving forward. You've used the term 4 corners of the contract a couple of times. And we had a nice conversation before the public part of the call started that really it's a rectangular piece of paper is really what's being referred to here, whether it's a virtual communication or a signed paper that presumably whenever any of us enter into a contract, we have preconceived notions on compensation, quid pro quo, you know, what's in it for me and what risks are established in this relationship. And that it really is our responsibility working with our business partner, whoever we're conducting business with. Part of that transaction is to identify the ideal value exchange and the perceived risks and all that. And that's part of the agreement. that, oh, I didn't think of that, is not really a legal defense if I'm understanding this correctly.
Exactly, exactly. And so to Ethan's point, and Ethan and I had talked about this, you could enter into an oral agreement if you wanted to, right? You know, the problem is, well, how do you prove what it was if a dispute ever arises, right? So therein lies the challenge. Well, what did you really agree to? One of the conditions to a valid contract is a meeting of the minds. You know, both parties are on the same page about the expectations and what we call the benefit of their bargain, what they're going to get out of it and what they're going to do in exchange for that benefit. And so the best evidence, right, of what the parties have agreed to is a document in writing and signed by the parties. So, you know, Ethan asked the question, well, you know, what if people are exchanging emails and going back and forth? Could that create a contract? And the answer really is, well, it depends. Right? You know, was there a meeting of the minds? And arriving at that conclusion, especially, you know, in front of the courts, can become very costly, you know, very time intensive. And so again, the purpose of coming to a written agreement that the parties sign, again, creates a certain level of certainty about what the expectations of the parties are and what your duties and obligations are.
And one last thought, and the floor is yours. Something that I think is in a lot of our minds right now, whether we are we're the provider perhaps or the payor in a contract. A term you used also was allocation of risk. And I'm reminded of the fact that it's a continuum. It's not an either or, that there are circumstances when perhaps my risk as the buyer is extended only as far as my security deposit. You know, that it may be forfeitable, but it doesn't mean I have to pay for the whole wedding.
Exactly.
Or perhaps, not to take us too far afield, even though that's usually what I'm good at, is the idea of insuring ourselves against risk. Travel insurance is something that comes to mind for me right now. That if I'm
business interruption insurance,
yes,
you know, is something
yes.
we'll, you know, so these are kind of the practical things that, you know, we'll talk about, like, you know, so if these if these doctrines really don't work for you, it doesn't make sense. And again, courts are very reluctant to allow an argument like this to go forward. You know, it's very challenging. You know, what are the practical ways, you know, that we can think about this? And I do want to back up a little bit to the force majeure clause. To be clear, performance under a contract could be excused, but typically not payment. So this does not include payments due under a lease, payments due potentially to your utility company, agreements to make payments under a loan, your duty to supply goods, to ship goods, different acts and things that, you know, benchmarks that you might have to meet might be excused, but typically not payment. So again, there's circumstances in which invoking force majeure, you know, could really benefit you, but if what you're really needing is relief from lease payments, you know, we'll talk about this a little later, but you might just be, you know, in the best position to negotiate with your landlord or your tenant, you know, as the case may be. The last thing I'll say on frustration of purpose is that making a profit is generally not a sufficient argument. It's not going to pass muster to say, well, my purpose in entering this contract was to make a profit. I mean, typically we assume that that's the case on both ends, but that purpose isn't specific to your contract generally. So that's not going to be a good enough argument typically to say the purpose of my contract has been frustrated, because in that case, anytime, you know, an agreement goes south, anyone could say, well, my purpose has been frustrated, right? You know, people experience that all the time. The next defense to contract that we'll talk about is impossibility. This is a doctrine that excuses a party's performance when an unforeseen and unanticipated event makes performance objectively impossible. Like, you just can't do it. Neither party can do it, or one party just can't. Financial hardship is not enough, even to the point of bankruptcy or insolvency. It's again, these things are very tough to invoke, you know, very high standards. And it's not good enough to say, well, my performance under this contract is going to make me go bankrupt. Impossibility is not going to be the argument that you want to make. And again, maybe we're looking more at it in a negotiation type situation. But it's got to be objectively impossible.
Hurricane washed my hotel off.
Exactly,
yeah.
Exactly.
Gotcha.
It's similar to frustration of purpose, but the difference between impossibility and frustration of purpose is impossibility concerns the duties specified under the contract, like what you must do. Whereas frustration looks at the reasons we got into the contract to begin with. So if you think about a situation where Bob is leasing space from Aaron so that Bob can open a restaurant. It's a wonky one, but there's things out there that happen like this, and you can be creative with it. So that Bob can open this restaurant that serves only Tibetan lizard meat. Let's say the city rezones the property that Bob was going to rent, and they say no more commercial use. Well, now we've got a situation where it's impossible legally to perform the contract, right? Bob can't be operating a business in a place that's now been rezoned where he can't operate for commercial use. And Aaron can't lease him that property legally. And so therefore performance on both ends has now become impossible, and both parties' performance would be excused. Similar to, Ethan's example, a fire burns the building down. Well, it's impossible to lease that space now, on both ends. And again, we're looking at excusing the parties, obligations of an agreement there because you just can't do it. And kind of thinking about how that works in comparison to frustration of purpose. So let's say, Bob enters this lease with Aaron. He's going to serve his Tibetan lizard meat. Well, Tibetan lizards go extinct, and now he can't. That's a frustration of purpose. Bob would have never entered into this lease, and Aaron knew that Bob would have never entered into this lease if Bob couldn't get himself that Tibetan lizard meat to sell at his restaurant.
Yet, if I understand contract law, if it's against the law in this country to serve Tibetan lizard meat, the contract would be void on its face and neither party would have action.
Correct. So, there's contracts that we call they're void ab initio. It's just a Latin word from like at the outset because it's illegal to do that. But there are certain things that maybe it wasn't illegal to do it at the time that you entered into the contract, but circumstances have then changed,
Gotcha.
Which now make things impossible, legally impossible for you to perform. So yes, that's, if you enter into something from the outset, that's illegal, you don't get to then go to court and say, judge, enforce my agreement. It's not going to fly.
In states dealing with legalization of cannabis, there's probably movement both directions.
Exactly.
Yeah.
And so one of the things that we have to look at in all these doctrines is what's foreseeable at the time. So, someone could enter into a contract, World War II breaks out and they say, they've got a lease for a bar or restaurant. Let's talk about prohibition. Someone's got a lease for a bar or restaurant. Prohibition happens. They're going to say, okay, A, it's impossible for me to perform under this because now it's illegal. And B, the purpose of this contract is now frustrated because you can't get alcohol anymore. So you have to look at what's foreseeable at the time. If we're in the middle of World War II, for example, and you enter into a contract and you say, well, I've got a labor shortage or I can't get supplies, I can't get the materials that I need. The court might say, well, it ought to have been foreseeable to you that this was going to be an issue. And so we're not going to protect you over things that you should have dealt with in your contract and that you should have reasonably anticipated having to deal with. So these things really have to be, unforeseeable, unexpected events that either A, weren't addressed in the contract and B, really couldn't have been because why would you ever expect that would happen?
This might be
outside of a force majeure clause when we're talking about the things we never thought were going to happen that then happen.
Right. And again, sorry to interject, but you used another term. I'm thinking of, it's probably overused in civilian situations, but the reasonable person standard. The fact
it's
that,
real.
A lot of this isn't really mystifying. It's really just.
There are, case after case after case, there's a whole body of case law, construing what's reasonable under the circumstances. And so a lot of these situations are very fact intensive, which, then becomes the challenge. If you're going to litigate this, right, like this takes time and money, some of these things can be subjective, you have to make your argument on either end, right? And so there, there's definite case law out there to say what a reasonable person should have known under the circumstances or ought to have done under the circumstances. And so again, that's where it kind of becomes critical to talk with your attorney, because I think, as business folks, and, I tend to think of myself as a business person in some way, right? Being out there, in the practice of law, bringing a client, working for a firm, I mean, there's things that you have to think about, and maybe we're not always thinking about them from a legal perspective, but from a business perspective, they make sense. And so it's important to sometimes kind of step back, speak with an attorney, just because I don't think it's reasonable or foreseeable, or maybe I do, what does the law actually say? Because a lot of this isn't always intuitive. And in some cases, you don't know what you don't know. So it's important to kind of find the people that do.
Well, and I think it would be fair to say that many of us are surrounded by legal transactions we don't even see. So we become desensitized to the fact that if I sit down in a restaurant and order food, I'm expected to pay for it, even if I don't prepay. And name it. If I drop my car off for service and they perform things to it, the mechanics lien is a real legal construct.
Exactly.
But we just don't see it because we're in a developed country and we just...
Well, it's run of the mill, and these things just go on every day. And so, Ethan and I were talking to, and I think, what I've seen in my practice is, I work with a lot of business clients who, know the law, and they're very savvy as it applies to them in their business, but I think the challenge with COVID-19, for example, is these are just things that no one ever thought about, right? Like, we didn't think this was going to happen. These aren't your day-to-day transactions. I work with clients who, supply auto parts, for example. And so, we're filing financing statements, with the Department of State, so that people are on notice that they have, a purchase money security interest. And so they know their rights and their duties and obligations for these day-to-day transactions. Absolutely. Right. But, I think a lot of lawyers are even finding themselves, oh gosh, right. Like, I have to go back to contract law 101 to kind of think about these things that generally don't come up, on a day-to-day basis in their practice. And, again, I don't know how many attorneys have really given a lot of thought to what's in their force majeure clauses, and business owners too, right, prior to an event like this. So kind of the last doctrine that we'll talk about is impracticability. It's one of those great legal words that I think when I got to law school, I was like, who made this up? Impracticability is the word. And it applies to the sale of goods. It's governed by the Uniform Commercial Code, which has been adopted in New York State. And it's similar to impossibility, but it's got a little bit lower of a threshold and actually takes economic factors into consideration. And so what this does is it excuses performance that could only be accomplished at an excessive and unreasonable cost, where it would completely just be unfair and unjust to expect that someone would undertake this financial burden to perform the contract because it's so outside of the scope of what they thought that they were signing up for economically. Again, this only applies to the sale of goods. Again, the event must have been unforeseen. It shouldn't have been foreseeable, and then we're going to say, oh no, now it's impractical, it's more expensive than I thought it was going to be. So if we're hearing from the Fed chair, we're expecting labor shortages, we're expecting this, and you're entering into the contract, and then later want to claim, well, I couldn't get the labor that I needed to produce these, again, things have to be, unforeseeable. Again, the economic circumstances are not relevant when you're looking at impossibility. It's got to be objectively impossible to perform. The building burned down, the neighborhood's been rezoned. I can't operate my business there anymore from a legal perspective. So here, increased costs and market conditions aren't enough. I mean, it's got to really be severe. If you're, buying widgets and you have to buy, a component that goes into those widgets, typically for 30 cents, and now all of a sudden you got to buy them for 45 cents a piece, that's different than now I have to buy them for 3 cents or, $3 a piece to put into my widget. I mean, again, facts and circumstances, like what constitutes, a severe and undue hardship. But this is really the only doctrine where we're going to look at kind of the financial burden. One thing to consider here is what are your alternative options? Can you still get it done in a reasonable manner? Maybe it's a little bit more expensive, but not extremely more expensive. But again, that's limited to the sale of goods.
Not services?
Pardon? Not services, no.
Okay.
No. So the Uniform Commercial Code only applies to the sales of goods, but not services. And it can get a little funky where we've got contracts where it's both, where, you're both purchasing goods and services. And so what do you do in a case like that? And courts will say, well, what's more? What's right? Like if we're going to sit down and look at the agreement and divvy it up, is it primarily services or is it primarily, you know, the purchase of goods or the sale of goods? And so again, you know, that might be a case where you want to get an attorney involved to say, hey, I'm not really sure. Do I have a services contract or do I have a goods contract? You know, which one is it? And so, you know, depending on what side you're on, you may really want it to be a goods contract if you want to invoke that defense of, you know, impracticability, right? You know, if you're on the other end of it, you're going to say, this is a services contract and you cannot invoke that defense here. So again, it, you know, it decides, or it depends on the side that you're on. And these are all very facts and circumstances analysis that, you know, you really have to work through. So the last doctrine, I mean, it's called illegality, but really we talked about this before, and really it falls under the heading of impossibility. You know, here we say if it's illegal to do it, we're going to say it's impossible to do it, and therefore performance can be excused. So again, not something that was illegal at the outset, you know, at the time that you entered into the contract, but has since, you know, things have since changed, where your performance and other parties' performance under the contract is rendered illegal.
Like when I was a kid and the drinking age changed, if my graduation party was scheduled at a hotel and there was going to be a bar and I can't pour my friends alcohol anymore because they changed the age. Yeah. And,
you know, you're looking at a situation where you might say, okay, well, you know, 80% of the guests were going to be your friends from high school. Do we have a frustration of purpose?
Right.
And, you know, again, a court might say, well, not completely. There's still, you know, you can still get food. You still
our parents will drink. Right. Yeah, exactly.
You know, I'm sure there's some people there who will take advantage. And so again, you know, these are very nuanced conversations. They're very facts and circumstances intensive. And, you know, they're high thresholds to meet because courts really don't want to disrupt the agreement of the parties. You know, they trust that as business people, these agreements are, you know, whether you have an attorney or not, that they're freely negotiated, you know, no one forced you into the contract. And they're going to say, you know, again, if you wanted something in your contract, you know, put it in there. You know, one of the funny examples to me is, you know, I saw a lease agreement from a client. He had like an addendum on the end of it. It was like 2 pages long, and it was like, no lizards, no water beds, no this. I mean, the most obscure things that you could ever, and I'm like, what? Like, and he goes, these are on my addendum because these are all things that have happened. Mm-hmm. You know, so he got to a point where he was, I'm putting it in my contract, right? And so, you know, the great thing here is we have, you know, freedom of contract. And if you want to agree to something, agree to it, you know, and incorporate it. It may sound silly, it may sound obscure, but what's the harm in taking a little bit more time to really make sure that you're protected and again, do, you know, allocation of risk. So kind of thinking about things from a practical standpoint, you know, we've talked about how these doctrines can be challenging to invoke, you know, facts and circumstances intensive, which takes time, which means money. You know, the challenge now too is our court systems are going to be backed up for quite some time after being closed for so long. So how long before you're even going to get in front of a court or with attorneys who can help you reach a settlement or an agreement compromise on how you're going to proceed with another party on one side of the contract or the other. It might be so far out that it may not even be that helpful at that point, depending on the size of the contract, how quickly you need things. And so one of the things I think, and people have been doing this, right, is negotiations between the parties, right? I mean, I think we're finding in a lot of cases that people are being reasonable and understanding, you know, what's going on is kind of bigger than all of us, and working together to find solutions that make business sense for both parties to the extent that we can. Just because you made an agreement doesn't mean that you can't make an agreement to agree otherwise. Most contracts include language that say something along the lines of, you know, this agreement cannot be modified orally. It's got to be in writing by the parties. So there's nothing to say that parties can't later then go back and say, hey, you know, we're in different footing now. Circumstances have changed and things are different, and we're going to make an agreement to modify the terms of a specific agreement, you know, whether it's permanently or for a specified period of time, you know. And there, I think it's, you know, working together with your advisors and working together with our business clients to understand their businesses and how things, you know, work out there for them to come up, you know, with terms and language and kind of craft something that really works for the parties and addresses the situation, you know, at hand. You know, we talked about this before, insurance. Another thing to look at if you haven't already is, you know, if you have business interruption insurance, kind of what that covers, and, you know, maybe having a phone call with your insurance agent, if you have insurance like that, to say, you know, what types of situations does this cover? And if you don't have it, you know, thinking about whether it might make sense to look at something like that going forward. You know, I think we're in a very, in some ways, a binary situation, you know, where we're looking backwards, you know, to deal with things that we never thought were going to happen, and how are we going to deal with that? But also going forward, okay, now that something like this has happened, how do we protect against it in the future?
Yeah, something that you brought to mind was the Better Business Bureau is actively involved in the chamber. Dispute resolution as well as reputation management, things like that. One of the benefits, I suppose, to a strong early contract is avoiding the need to seek judgment. Because much like individuals have a credit rating and a legal history, businesses really have the same thing. And, you know, if you ever wind up with a rap sheet of your own, especially in this day and age where you can find anything on the internet.
Yes.
That it's presumably in both parties' best interest to negotiate in the least expensive, least injurious, fastest, most efficient way, instead of just, you know, that's it. We're going to court. Well, no offense to the present company. It gets expensive.
None taken, none taken.
It becomes adversarial, and it becomes permanent. Before we started the call, we were bantering and back and forth about the word memorialize, the idea that concepts and certain information becomes part of permanent record. And that, you know, a simple misunderstanding or maybe a not so simple, but, you know, affordable, if perhaps expensive misstep, it may be tempting to want to prove a point, or it may be tempting to want to win this one.
Right,
but
right.
You know, you have to calculate in the cost, the time, the goodwill.
Yeah, and unfortunately, you know, I've had a number of clients come to me and say, hey, you know, I've got XYZ situation, you know, what are my options here? Do I have legal recourse? And unfortunately, you know, in a good number of cases, the answer is you have legal recourse, but it might cost you more money, you know, than it's worth. You know, are you going to spend $1,200 to get $600 back?
Right.
You know, the challenge, you know, with the judgment and, you know, to your point, Ethan, I think it's always, you know, worth it to think about who you're getting in business with. You know, there is an ability to work with different companies or to work through your attorney, depending on the size of the agreement that you're entering into and how much money you want to spend at the outset. You know, if we've got a $500 agreement for someone to come paint my house, you know, or a room in my house, I don't know how much time I'm going to spend, you know, figuring out who Bob is, if Bob was recommended to me by a friend, right? But sometimes it really makes sense to investigate this person. And, you know, we have a wealth of information available to us publicly to spend the time and do the diligence to figure out who we're contracting with. I lost my train of thought on what else I was going to say, but
that's all right.
Yeah,
there's so much to talk about.
I know there's so many things, you know, but it's, you know, it's important to know who you're getting into business with.
Well, and, you know, not to make fun, Serena, I often lose my place in conversation, and I'm thinking that it's easy to do that in a contract. That's why you want professional eyes that are not embroiled in the details.
Mm-hmm.
Take a fresh look and say, you know what, you've completely overlooked this component. Because to your point, I think many of us are experts in our own life or our own business, but really don't understand much about anybody else's. So that's partly why we sought out that other business, is because they do work we don't.
Exactly.
That's why they're our client or our vendor or whatever. So we could try to become an expert in what they do, but then all we've done is bought their business.
Right.
Or we could, yeah, we could ask
or we're taking time away from our business to, in some ways, kind of do their job, right? And so then you're looking at a, you know, an efficiency and a profitability issue. So, you know, that, you know, you make a great point, right? Like that's the point of business relationships. You know, I say all the time, I go to a hairdresser and I love her because I can go to her and say, what are the kids doing these days, right? Like the worst for me is when I go and they say, well, what do you want? And I'm like, well, I don't know. What do I want, right? Like, this is what you do. You do your job and I do mine, and I'm going to you, you know, for guidance. And, you know, a lot of ways my clients, you know, come to me for the same thing. And it's a relationship, you know, where you talk about, well, this is what I was thinking about. What are your thoughts? You know, and you have those back and forth conversations where, you know, maybe my client has the big picture and I am like, well, have you thought about this detail? Or maybe they're very detail oriented and you can say, you know, well, broadly speaking, let's back it up a little bit. So, you know, I think that that's, you know, a lot of times where the benefit comes in is just getting another set of eyes on something and a different perspective.
It's interesting you should mention about some people are more detailed than others. I imagine there are circumstances when details are not your friend. If your language becomes overly specific, you may actually carve yourself out of what you wanted to be protected about.
Right, you know, and it really just depends on, you know, the type of agreement, what it is, right? Like if we're looking at a force majeure clause, you want to be super specific because the court is going to say, well, if you didn't put it in there, we're not going to put it in there for you. Even if you've got this catch-all clause, it's got to be pretty similar to what you already talked about. You know, where in other cases, depending on what my obligations are to the contract, maybe I don't want to be that specific, right? So some of that is strategy and you know, and it's a dance of going back and forth between the parties, right? Because another party might say to you, hey, you don't want to be really specific, but I want to know exactly what I'm getting here. So you know, a lot of this is crafting language, you know, and rarely do I ever see two agreements that really ever look exactly alike, unless we're talking about, you know, a purchase agreement to buy a house in Monroe County. We've got standard forms for that, but really, you know, agreements are specifically tailored, you know, as they should be.
Very good. To circle all the way back to the beginning, there is a slide deck that we're going to share with everyone who registered for today. So at this point, perhaps, Serena, would it make sense to open it up for some questions? I'm wondering if there's people in the audience that have, anybody want to raise their hand or use the Q&A section perhaps for questions? I know my head is full.
It's a lot. It's a lot.
Well, like I said earlier, I think we become desensitized perhaps that every time we exchange currency, we're entering into a contract, you know, or maybe we're, you know, someone like you might specify that maybe that executed the contract, but
right.
You know, anytime we exchange value knowingly and consensually.
Right, there's expectations.
Yes.
And there's obligations that come with that.
Yes. I'm going to bet people are metabolizing their lunch because I don't see any additional questions. Plus, you've been a fantastic speaker. Thank you.
Must have covered everything.
Well, or scared folks a little bit. I wouldn't be surprised.
I know.
You know, I think we're fortunate to live in a community where, you know, we're a mature workplace. You know what I mean? A lot of our folks know each other. We have good quality resources such as yourself. Mm-hmm. We have a relatively strong economy, even in times like this when it gets a little, when we're corrected. Yeah. But that I think our basis is not only trust, but good business. That I think one has a hard time existing without the other. Mm-hmm. But that if we don't codify things, memorialize things, it'll compromise that trust eventually. So thank you for all that you and Underberg and Kessler do for our community. And in the absence of any other questions, I'm going to give folks the balance of the afternoon to spend as they wish. So thank you again, Serena. Thank you to Underberg and Kessler, and stay cool out there.
Thanks for having me, Ethan. It was great being here.
Certainly. Bye, y'all.